Hey there guys, really pleased to get this video uploaded before the new academic year starts and you start wasting your money on textbooks and things. Basically, one of the most popular and requested topics on this YouTube channel is commercial law, and I've always been a bit hesitant doing it because on this channel I really want to focus on the core LLB subjects so they're available for as many people as possible. However, I do understand that commercial law is a popular topic and people want to do it. So over the summer I've managed to put a whole course together on commercial law that covers a range of topics including sale of goods, remedies available to buyers and sellers, the law of agency, different things like that. In fact, what I'll do is I'll put a whole list of the topics in the description below. And so that course, which is more than 3 hours worth of content, is now available on my website at uklawweekly.com. Again, I'll put a link in the description below, but it's on videos and then you go to commercial law, and that's available for £15, which is like half the cost of a textbook, and it also helps me to support the channel as well. I'd rather do something like this where you only pay something once and then get a really good product as a result of it, rather than something like a Patreon where you're just sort of paying month by month and there's not really much I can offer. At least this way it's a one-off cost for you. Hopefully you save money by not having to buy a huge commercial law textbook. You help support the channel as well, and everyone wins. So in terms of this channel over the next few weeks and months, I'm going to continue uploading stuff probably on the core subjects of equity and land law, but I'm also going to work on doing some of the other optional subjects as well. So I've already got a few videos sorted on employment law, and I'm going to continue doing that. And we'll also have family law coming up, maybe towards the end of 2018, but possibly into 2019, depending on how things go and priorities and stuff. But yeah, if you are doing commercial law this year, then do make sure to at least check it out. And as a sort of preview to that, I've got the first video, which is an introduction, and that's coming up right now. The main issue with commercial law is that it's really difficult to define. It's not like there is one single body of law or statute where everything is helpfully contained. Instead, commercial law is really just all about facilitating the transactions of businesses. However, there are some principles that underpin commercial law, and that's where we're going to start this lecture. The main principles of commercial law are set out on this slide here, and we can take a minute just to go through each of these in turn. And so the first point is certainty, and this makes a lot of sense because if you imagine I have been running my business in a certain way and have always done so, then as we move forward into the future, then I have a reasonable expectation that I should be able to continue running my business in that way as we move forward. And the law, and in particular commercial law, is really important for guaranteeing that certainty and ensuring that I can continue to do business in a particular way. Responsiveness, though, is also another apparently contradictory duty of commercial law. It seems to go against this idea of certainty, but it's a fair point as well, because as the ways of doing business change, the law should also adapt to that change as well. We see that in the relatively recent past with e-commerce. As the internet developed and e-commerce developed as well, the law also had to change to be responsive to that. Next, we also have laissez-faire. This is a French word that translates roughly to let it be, and this is the idea that the law should not be overly involved in the life of commerce. On a day-to-day basis, the law should have no impact on the way that businesses actually do things, and should allow them to continue their business with as much freedom as possible. The law should only really be intervening where it needs to, rather than intervening for the sake of it. This links into the point on simplicity, and the law should be as simple as possible, allowing businesses to continue in their work without overcomplicating things when all they're trying to do is buy and sell particular goods. The law should also be efficient as well, so it shouldn't take up a lot of businesses' time
to actually be able to comply with the law. And you can imagine for certain types of businesses this is really important. If I was selling fruit and vegetables, for example, a delay of more than a few days would just mean that all of the fruit and vegetables would go bad, and it would be impossible to actually continue running my business. Finally, commercial law also increasingly needs to be international. We've already spoken about e-commerce and how this introduces an idea of internationality, but also the ways of transferring goods are also improving all of the time. Air travel is much more prominent now, and carriage of goods by sea is also becoming more quick and efficient as time goes past. So the main focus of this lecture today, though, is going to be on personal property. And there's a distinction between personal property and real property. Real property is just land, but personal property is a little bit more nuanced, and we can split this up into the 3 different types of personal property. The first of these is chattels real, which is leases of land. Then we have the main focus of our lecture today, which is things in possession. In other words, objects that you could actually hold in your hand. And finally, we have things in action, which are split between documentary intangibles, that might be things like bills of lading, and pure intangibles, which might be something like a debt. And all we need to know at this stage is that intangible means something that you can't hold. So it's not a 3D object that you can actually put in your hands. So a pure intangible like a debt, you can imagine that a debt is something that you might be able to possess, but it's not something that you can actually hold. One of the mistakes that people tend to make in relation to personal property is they think it's actually about the property itself, rather than the rights in relation to that property. So take, for example, the sentence, "I own this book." Now, the important part of that sentence from a legal perspective is not the fact that I'm owning a book, but rather the fact that I have ownership over something else. And it's that relationship or that action of ownership that is really important from a legal perspective. Rights in property, such as ownership that we just mentioned, and also possession as well, that are about my relationship with a particular object, can be contrasted with personal rights, where, for example, I might be able to sue another person, and there my relationship is not with the property itself, but with that person who I am actually suing. So let's have a look at ownership first of all, and then we'll move on to possession a bit later. And ownership is really the key right, because it's what's left over after other rights have actually been granted. So imagine that I own a DVD, but I lend it to a friend. Now that friend may be able to then say that they possess the DVD. They would be able to use the DVD by watching it on their television. They might even be able to invite friends around and charge them and generate an income from having that DVD. But after all of that, who actually still owns the DVD? Well, that would be me. And so we see that ownership is that residual right that still remains after everything else is gone. We also can split between joint ownership and co-ownership. Joint ownership, you don't own anything as an individual. It would just be that the owners together have ownership over, say, a particular item or group of items. However, for co-ownership, each individual owns a particular share of the whole. And so in the Ipatina from 1988, we had a shipment full of oil. And you can imagine there that in the area of co-ownership, we would say that if I owned 50% of that oil, it doesn't matter that in the tanker all of the oil is getting mixed up and there's different particles, and it's impossible to say which atom of oil belongs to which person on an individual level. What we can actually just say is that, okay, well, we have a tanker full of oil, one person owns 50% of it, the other person owns 50% of it, so when it arrives at the destination, we'll just take 50% out, give it to me, take the other 50% and give that to another person. One of the other things that we will come up onto later on, and those of you who have already studied equity and trust will be familiar with this, is that there's a distinction between legal and equitable ownership. So in this example on the screen, we have person A who transfers property to person B, and when that transfer of property occurs, person B becomes the legal owner of that property. However, person B can also hold that property on trust for another person, person C, and that person C would then become an equitable owner. And so this used to happen in relation to sort of younger people, and the property might be transferred to a legal owner B, but it would be held on possession for these younger people who might not have the responsibility or the ability to manage property at that time. And so they would be the equitable owners, but there would be a distinction between the legal owner and the equitable owner as well. So understanding that relationship will prove important later on. For the time being though, let's move on to possession, and possession consists of two different factors. Firstly, we have the exercise of control, and that can vary depending on the nature of the goods. You can imagine that if I am said to possess something like a washing machine, then the fact that that washing machine is installed within my house means that I am exercising control over it. However, for something like a car, I might decide to park this by the side of the road, and so the question is, am I still exercising control over it if I then go to the shops or go for a coffee, go to a restaurant, something like that, and just leave the car where it is? Well, I can still be said to it because the nature of the goods itself means that the nature of exercising control changes as well. And so you can imagine that with a car, the fact that I'm still in possession of the keys is a signifier that I'm still exercising control over the car itself, even though I might not even be able to see it at that particular time. Secondly, we also have an intention to possess as well, and this is called the animus possidendi, and this can be compared with something like the mens rea in criminal law, where you have to have a criminal intent to do something. Similarly here, there's no criminal element, but we can see that there has to be an intention to actually possess the goods itself, and in particular, an intention to exclude others from that possession. A very good example of this is in Wilson and Lombank Limited. Wilson bought a car from someone and then decided to undertake repairs to it, so he left that at the garage. However, little did Wilson know the car had actually been stolen by the person who he bought it from, and so Lombank Limited decided when they saw the car at the garage to just take possession of it and take it back to their own garage. Wilson wasn't very happy about this because he had bought the car in good faith, and so he sued for trespass to goods. And the key question was, well, did Wilson have possession of the car? So we can say, first of all, even though it was at the garage and not within his sight, the fact that he had the car keys was really important for him exercising the control. And did he intend to possess the car as well? Well, I think we can say yes, that he did, because he obviously intended to return to the garage and pick the car up. And also in the first instance, he bought the car in good faith and then intended to possess that car as well. One of the other things that we can talk about is bailment, and this is a limited right of possession which is transferred from a bailor to a bailee. And the best example I can give here is, imagine if you were selling goods on eBay and then they had to go over to someone who you were selling them to in America, for example. Now the chances are you wouldn't deliver the goods yourself, you would use a carrier, someone like UPS or FedEx, one of those types of companies. And in that situation, you would be the bailor because you possess the goods in the first place, and then you would transfer a limited right of possession to the bailee, which would be the carrier, UPS or FedEx, and eventually they would then pass the goods on to the person who's actually bought them in America. Now the bailee in this situation, so FedEx or UPS, has to take reasonable care of the goods. Even though they can seek to limit their liability, there are limitations on the extent to which they can do that. So say for example they get sort of lost in the post, then there is a certain responsibility that the carrier has in that situation to refund you. So the particular example that we can use there is things like the Consumer Rights Act 2015, which is not as much to do with commercial law, but it does have an impact in that type of situation. And also the Carriage of Goods by Sea Act, which also has an impact in this area as well. So during this time, as I said, the bailor does pass on to the bailee a limited right of possession. And so the bailor does retain something that's called constructive possession. And this would be really important for retrieving the goods if, for example, FedEx or UPS, they went bankrupt. So in that situation, the bailor would still have constructive possession and would be able to get the goods back from the people who are administrating the bankruptcy. This constructive possession can also be passed from one person to another by attornment. And so the problem there is that all three parties have to agree, in the sense of you, the person selling the goods, the carrier has to agree as well, and also the person who you're selling the goods to in America would also have to assent to this attornment. And we see that in the case of Godst and Rose from 1855. Now, the possession of a bailee, that possession right that they have as the carrier is still protected against interference by third parties. And so if the goods were, for example, being kept in a warehouse and someone interfered with that possession in the warehouse, then they would still have a right to sue them. However, full recovery by a bailor, so the person who actually owned the goods in the first place, would prevent further recovery by the bailee, the carrier, and that also works in reverse as well. And so this case of O'Sullivan and Williams, all that the law is really saying here is that you can't really claim twice for recovery of possession where that's been interfered with. Claiming twice against someone who has interfered with the possession, once from the bailor, once from the bailee, would clearly be unfair against the person and would be something like a double claim. So if the bailor does not have right to immediate possession, in other words, if they can't actually sort of lay their hands on the good, or it's very clear that they don't really have any intention to possess, as we saw with that animus possidendi, then there is no claim in trespass or conversion. We saw that in this rail case from 2005, where the goods had clearly gone to Network Rail Infrastructure, and HSBC Rail had no clear possession over the goods at that time. If there is a dispute over possession, then the court has to work out whose claim is paramount. In other words, who has the better claim of possession in those particular circumstances. Finally, at the start we did talk a little bit about dealing with intangibles, so we can come back to that here. And documentary intangibles such as bills of lading that detail the items that are on a ship that's in transit, possibly in the middle of the ocean at the time, that bill of lading can be transferred from a seller to a buyer by simply transferring the document. So once I pass the bill of lading from the seller to the buyer, essentially the goods also transfer with that. The best way to think about this is that a single document can represent, millions of pounds worth of goods, and they often will do, especially when we're dealing with carriers and goods that are going to be in transit for a significant period of time, and those can be transferred. Pure intangibles, which are things that you can't touch at all, we did mention about debt earlier, but we can also think about things like shares. These can be assigned to another person, but they have to meet the requirements of section 136 of the Law of Property Act 1925. And so that assignment has to be done in writing, has to be signed by the assignor, i.e. the person who is actually transferring the debt or the shares, and notice also has to be given to the debtor when we are assigning a debt to another person. And so that is our introduction to commercial law, as well as a bit of an introduction to personal property as well.
Now, we could have gone into a little bit more depth on some of those subjects, but the idea here was just to give you some of the basic underpinning of commercial law that you will be using throughout this course. In particular, some of those principles right at the start to do with commercial law are important to remember when answering any essay question, as it's important to remember what role the law plays in relation to commerce and the economy in general. Meanwhile, personal property and some of the ideas around ownership and possession are going to be really important throughout the course and will often come up in the context of problem questions as well. So understanding who owns a piece of property or who has possession over certain goods is going to be hugely important. Well, that's all from me. I'll see you in for the next lecture, but for now, bye!